in the literal approach. Yeah. In other words, it is the plain meaning of wordings by dictionary, for example. Other definition, it is an approach to statutory interpretation, which is the court is to give a strict interpretation to the intention of Parliament as set out in the words actually used in the statute. Look at the word of the act. Yeah. Explanation according to Jeep JC is as follows. If the language of a statutory provision is clear and unambiguous and is consistent and harmonious with the other provisions of the enactment or statute, and this can be applied to the subject matter with which it deals, it must be given its ordinary and grammatical meaning. If the interpreting the literal meaning of the word in the act, for example, in the case of Erfi versus Judge of the City of London Court in 1892, where the Lord answered, if the words of the act are clear, then you must follow them, even though they lead to a manifest of absurdity. The court has nothing to do with the question whether the legislator has committed an absurdity. The case of London and Northeastern Railway Company versus Berryman in 1946, you can read in the textbook. Widow tries to claim compensation, where the widow tried to claim compensation after her husband killed while oiling railway tracks. The fatal accident happened and gave compensation to those killed while relaying or repairing the track. Her husband was actually maintaining it, so she got nothing because of the word of maintaining. Yeah. In the case of Mager and St. Mellons versus Newport Corporation, it was back in 1950. The Lord's Chairman was said that we are to be governed not by Parliament intention, but by Parliament enactments. In the case of Cheeseman versus DPP in 1990, Town Police Clause Act 1847 made it an offense to do so in front of passengers. On the street, the act defines street as any public places. Yeah. In the case of Cheeseman versus DPP in 1990, yeah, Lord Bingham referred to an 1847 dictionary when he decided that passengers mean anyone using the street for ordinary purpose. Therefore, the police were using it for a special purpose, and those were not the passengers. Let's discuss about the next topic, which is golden rule. On the slide, page 23, you will see how we describe this rule. Well, if there's two forms, narrow and broad, this is applied for the golden rule. Narrow golden rule, for example, in the case of Jones and versus DPP 1962, per Lord Reid said that if words are capable of more than one meaning, therefore then you can choose between those meanings, but beyond this you cannot go. Yeah. And according to the golden rule, the courts were to interpret legislation in a manner which is avoid obvious absurdities or inconsistencies. Obvious printing mistakes or simple slips were set aside, and the courts read legislation as if these errors were not there. Thus, the court has the right to adjust a literal meaning of wording if it would lead to absurdity, for example, irrationality or illogicality. Therefore, the golden rule is an extension of the retail rule that we discussed earlier. If the literal rule gives an absurd result, which is obviously not what Parliament intended, then the judge should alter the words in the statute in order to produce a satisfactory result. Therefore, judge might use the narrow approach or the broad approach. I'll give you example in this case for the golden rule. For example, Section 46 of the Administration of Estate Act in 1925, where required that the court should issue someone inheritance in certain circumstances. In 6 words regarding Bedford versus Bedford, in the court held that no one should profit from a crime, and so use the golden rule to prevent an undesirable result, even though there was only one meaning of the word issue. So the word issue. So the facts of this case are often misreported. A son murdered his mother and he committed suicide. The court were required to rule on who then inherited the estate, the mother's family or the son's descendants. There was never a question of the son profiting from his crime, but as the outcome would have been binding on lower courts in the future, the court found in favor of the mother's family. The golden rule second use of the golden rule is in a wider sense, is to avoid a result that is obnoxious or intolerable, horrible, to principle of public policy, even where words have only one meaning. So broad golden rule is actually we are going to discuss where words have a clear meaning, but following them will lead to a repugnant situation. The court will modify the word of the statute to avoid this horrible situation. In the case of broad approach, we can look at the case of Adler versus George in 1964, where there's only one literal meaning of a word or phrases, but to apply it will cause an absurdity. Then, under the broad approach, the court will modify this meaning to avoid absurdity. Defendant then changed under the Official Secret Act in 1920, which made it an offense to obstruct a member of the armed forces. In the vicinity of prohibited places, defendant claimed he was not in the vicinity of. Then court applied broad approach and applied the word in to mean in the vicinity of and change in the meaning of the word. In the case of the 6 words, 1935 is describing how broad golden rule works. The Administration of Estate Act in 1925 entitled the son to inherit the benefit of his deceased mother's estate. Son murdered his mother and wanted the money, so the court altered the law to prevent him from inheriting. Jim Martin said, where there is a problem with using literal rule, then the golden rule provides an escape route, means solution to literal rule. In the case of sick word in 1935, Lord Denning said, if Parliament overlooks a possibility like this, so the broad golden rule can fill in the gaps. Then we discuss about narrow approach, where the case of R versus Allen in 1872. This is an example of the narrow approach of the golden rule. The wording of the Offences Against the Person Act in 1861 had to be given a different interpretation for the crime of bigamy, because the way it was written meant that the crime could never be committed. The court used the golden rule and held that marry mean to go through a marriage ceremony. Under circumstances of use, it is compromise between the plain meaning or literal rule and the mischief rule, like the plain meaning rule. It will give the words a statute their plain ordinary meaning. However, when this might lead to an irrational result, then that is unlikely to be legislator's intention. Then the judge can depart from this meaning. Next, we are going to discuss about mischief rule. To understand the mischief rule, so you have to know the purposive approach. This gives a judge the most flexibility when deciding what mischief Parliament intended to stop. It was established in Hayden's case in 1584. When using this rule, a judge could consider what the common law was before the act was passed. What's the problem? Was it that with that law, and what the remedy was that Parliament was trying to provide? Fill in the gaps left by the act. The mischief rule, like it was described by Hayden's case in 1584, was described for different things. First, what was the common law before the making of the act? Second, what was the mischief and defect for which the common law did not provide? Fourth, the true reason of the remedy. And then the last one, what was the remedy the Parliament had resolved to cure the disease of the Commonwealth? So the court then interpreted the act in such a way as to cure the mischief. What's happened to mischief rule? We are going to discuss mischief rule in the next this topic, which is actually this rule is used when literal approach is not possible due to ambiguity, uncertainty, vagueness, logical defective, imperfect flawness, inconsistency, or incomplete. The mischief rule is a certain rule that judges can apply in a statutory interpretation in order to discover Parliament's intention. It is essentially asks the question, what was the mischief or trouble, disruption that the previous law did not cover? The example of mischief rule can be described in one of the page that I share with you. Look at the case of Smith versus Hughes. The rule was illustrated in the case of Smith and Hughes, where under the Street Offences Act in 1959, it was a crime for prostitutes to loiter, hang around, or solicit on the street for the purpose of prostitution. The defendants were calling to men on the street from balconies and tapping on windows. They claimed they were not guilty as they were not on the street. The court prevented the soliciting by prostitute on a street, and the question arose as to whether the prohibition extended to catch the activities of prostitutes who attract passers-by from windows or balconies. Then the judge applied the mischief rule to come to the conclusion that they were guilty, as the intention of the act was to cover the mischief of harassment from prostitutes. A prostitute soliciting ask for or seek for, in this case, that is actually the act that happened, out of her bedroom window was still breaking the law, allowing, forbid, prohibit, soliciting in the street. The mischief of the statute aimed to prevent was obviously public soliciting, whether it technically took place on the street or it's not. The court interpreted the aim of the legislation as being to clean up the street so that people could use them without being solicited by prostitutes, and held that the act did extend to those operating from windows or balconies. Thus, Under this rule, it will give the courts a wide power to investigate the reason for the passing of an act and assist them to interpret it in accordance with the parliamentary purpose or intention or intents. So remember, in the mischief rule, the court have given this rule a limited operation, exhibiting a preference for the literal rule. They have usually applied it only when there is some clear ambiguity or uncertainty in the statute. Next, we are going to discuss about the purposive approach. What is the purpose of the act? What was Parliament hoping to achieve? Mager and St. Mellons versus Newport Corporation in 1954 was an interesting example of this approach. Lord Denning said, "We sit here to find out the intention of Parliament and carried it out, and we do this better by filling in the gaps and making sense of the enactment than by opening it up to destructive analysis." The case of Mager and St. Mellons versus Newport Corporation back in 1950 was said, where Lord Scarman said, if Parliament